Morning, ladies and gentlemen. I'm Judge Tammy Long Hayward. This is the State Court of Clayton County, Courtroom 304. This is the civil calendar for July 29, 2026. This is the 10 a.m. calendar. I'll call the calendar. It's my understanding that we've some of these cases have come off the calendar, but I'll call them just to make sure that there's no one here for those particular cases. Case number one, Charles Bonner versus XYZ Corporation and Michelle Lynn Henson and some John Does. That case, the motion is moot, so that case has been excused. Case number two is Melody Collins versus James Omar versus Farmers New Century Insurance.
Andy Owens, I'm present for Farmers. Hello, Judge. Good morning.
All right, so next case on the calendar is U.S. Bank National Association versus Britta Davis.
Good morning, Judge. This is Catrice Helen. I'm here for the plaintiff, U.S. Bank.
Okay. Don't see anyone else on the screen other than attorneys or court staff. So we'll get to that quickly. Next is Lavina Vance, Emmanuel Gary, Demia Gary versus Canal Insurance, Abdul Bayor Trucking Company, and State Farm.
Good morning, Your Honor. This is Attorney Callan Hamby here on behalf of the plaintiffs.
Good morning, Your Honor. Frank Gaither on behalf of the carrier, State Farm.
Okay. And the next case is Demia. I'm sorry, I think that's a continuation. Arias Bass versus Michael Clark. Arias Bass, Michael. Okay, I'm sorry, that case is settled. All right, so let's get to. All right, Collins, Omar, Farmers New Century Insurance.
Yes, Judge, again, Andy Owens. I'm here for Farmers, the carrier. The plaintiff I've got a motion for summary judgment pending here. That's what we're here on today. Plaintiff has never filed a response to it, and the defendant has never been served. The facts are undisputed and pretty much just stated on the docket. Plaintiff and the named defendant were involved in a car wreck back on June 3, 2022. Plaintiff filed this case on the last day of the statute expiring June 3, 2024. Plaintiff never got service on the defendant. There are a couple of affidavits of service on file, and they show that the plaintiff never got any service on the defendant. Of course, the statute's expired, and my motion for summary judgment is predicated on the issue of whether or not the statute expired without service on the defendant, such that the plaintiff has met a statutory condition precedent to recover against her carrier. And I've got two cases cited in my brief that are absolutely on point. Cotton States versus Bogan at 194 Appeals 824. It's a 1990 case. And also Swanson versus State Farm at 242 Appeals 616. It's a 2000 case. Both of them, the facts are completely analogous to this case. In Bogan, the plaintiff filed her suit one day before the statute expired. In Swanson, just like this case, the plaintiff filed the date the statute expired. Neither got service on the defendant. In both cases, the carrier filed motions for summary judgment or motions to dismiss based on the lack of service and based on lack of condition precedent. You can't recover against your carrier unless you get a judgment against the named defendant. Can't get a judgment against the named defendant if you haven't served the defendant and the court doesn't have jurisdiction. So that's essentially my argument, Judge, and I think this case is subject to dismissal. And again, I have not heard from plaintiff's counsel in months, maybe even a year. So I think the case is probably abandoned.
Okay. Just one question, curious. Why MSJ instead of a motion to dismiss?
I've seen them styled both ways, Judge, and I'm not sure why. I mean, I know the court has the authority to convert it or consider it however the
just-
court
Just curious.
wants to rule on it. And I think when I filed it, I thought there might be an affidavit or something outside of the pleadings of record such that it would be summary judgment because the court would have to consider some motions. But then I saw on the docket that, the affidavits on the docket for service clearly show no service.
All right, so the court, based on what I have and what we've reviewed, the court's going to grant the motion. Do you have a proposed order, or did you send that in with the motion?
I can prepare and send one in, Judge.
All right, you do that. We'll go ahead and get that out to you.
And do I need to send that proposed order to you directly or to?
My staff attorney, Ms. Kiara Powell.
Okay.
My apologies, Judge. Could Kiara Powell put her email address in the chat?
Yes, ma'am. Ms. Powell, if you'll just send it to everybody so they can have it.
Yes, ma'am.
And good morning, Your Honor.
Good morning.
Hey, my name is Jason Stewart, and the case that we're here for, I didn't hear it called.
Okay, which case is that, sir? I may have
No.
skipped it. I'm trying to go down the line. Tell me what you're here for.
Yes, Your Honor. It's the Demia Hudson case versus Greenwood Motor Lines
I
DBA
did see
Ardell
that. I'm
carrier.
sorry. I think there's a Demia Gary in the previous case, and I think I thought that might have been a continuation. Because a name like Demia doesn't happen twice in a calendar, but it did today.
Yes,
So,
Your Honor. Understand.
Demia Hudson versus Michael Reynolds, Greenwood Motor Lines Protective Insurance versus Benchmark Rehabilitation.
Yes, Your Honor. And Jason Stewart on behalf of the defendants.
Okay.
And William paid on behalf of the plaintiff.
All right. So,
And Judge Edward, and I just checked, it looks like there hasn't been an entry of appearance filed for me in this case. It's being
Okay.
filed right now. That was an error on my office. I'm here handling the oral argument on behalf of Jeff Beard. He's the handling attorney on this case. I'm going to be assisting it with him. I'm going to be assisting the case with them, but the entry of appearance is being filed right now. But I wanted to make the court aware of that.
no problem. All right. So thank you all for bringing that to my attention. I literally looked at that and I said, oh, Demia Gary. And then I went to the next one. It was Demia Hudson. And I was like, maybe it's a continuation. So next case on the calendar is U.S. Bank National Association versus Brita Davis. So Ms. Helen, go ahead and present on behalf of your client.
Yes, Your Honor. So
I see that there's a counterclaim. I'm sorry, let me just for the record. So this is case 2025 CV 06484. And I see that the defendant has filed a counterclaim, but the defendant is not here. And the plaintiffs have filed the motion for summary judgment for a debt owed. So go ahead, ma'am.
Yes, good morning, Judge. I am here for U.S. Bank. U.S. Bank has initiated this attempt or complaint in an attempt to collect the outstanding debts owed by the defendant, Ms. Davis.
Are they the direct debtor or was there an assignment?
A direct debtor.
Okay. Go ahead.
And she was issued a credit card bearing the last four account number 6518. And defendant retained the card and made use of it for various purposes and cash advances. She breached this agreement by failing to pay the sum of money due in accordance with the terms and conditions of that contract. The defendant benefited from all charges made on that credit card and that account. U.S. Bank, the plaintiff issued monthly statements to the defendant. Defendant received those statements without protest and neither objected to them nor indicated that they were erroneous in any respect. She made monthly payments, acknowledging the debt owed to U.S. Bank. So there is an outstanding balance of $4,519.76. U.S. Bank has filed its motion for summary judgment. And in order to prevail on summary judgment, I just want to give a little case law. OCGA 91156, the moving party has the burden of proving that there's no genuine issue of material fact. And the facts, when viewed in light of the most favorable to the non-moving party, the defendant, warrants judgment as matter of law. And once the moving party for summary judgment has carried its burden, the burden shifts to the opposite party, and they must come forward with rebuttal evidence or suffer the judgment against her. And that case is going to be Hinckley v. Building Material Merchants. That's 187 Georgia Appellate 345. And in this particular case, I have seen the defendant's answer. However, there have been no defenses outlined in her answer at all. It seems a boilerplate template, but there are no defenses asserted here. Since U.S. Bank has met its burden, I do believe we are entitled to summary judgment. And again, to show that U.S. Bank is entitled to that summary judgment, plaintiff is required to show that the defendant entered into agreement or established an account with the balance and failed to pay. That case law is going to be Melman versus
Have you
FIA.
submitted all of that with your affidavit?
Yes, Your Honor.
Okay. Other question, is the total sum that your client is seeking $4,519.76, or are there attorney's fees, court costs, or interest payments?
There are attorney's fees, court costs, and interest payments. The principal balance is $4,519.76.
Right. What are the other amounts that you're seeking?
We're going to see court costs, which are $241, excuse me, and 50 cents.
Okay.
Attorney's fees, $350.00.
Okay. All right. Anything else?
No, Your Honor, we're just going to, and I understand the defendant is not here. We're just going to move for that summary judgment to be granted and an order to be signed today. I can issue a proposed order to that email and have that submitted to your court before the end of day.
That will be fine. So the court is going to grant the amount of liquidated damages at $4,519.76, $241 for court costs, $350 for attorney's fees. That total is going to be granted to the plaintiff, U.S. Bank. The counterclaim filed by the defendant will be dismissed for want of prosecution, and the motion for summary judgment is granted, and you can just present your order.
Understood, George. That's my only matter. May I be excused to email that proposed order?
Yes, ma'am.
Thank you, Judge.
Thank you. All right, Lavina Vance, Gary Emanuel, Demia Emanuel versus Canal Insurance Company, Abdul Bayer Trucking Company, State Farm Mutual. All right.
Good morning, Your Honor. This is Attorney Callan Hamby here on behalf of the plaintiff. This is a partial motion for summary judgment submitted by the plaintiff. I'm more than happy to outline the plaintiff's position if that's the court's preference.
You may.
Thank you, Your Honor. Today, the plaintiff comes before the court asking the court to grant their partial motion for summary judgment. In doing so, ruling that State Farm, the uninsured motorist coverage provider in this matter, owes plaintiffs coverage for the injuries that they suffered in the underlying motor vehicle crash. What happened in this case, Your Honor, is the plaintiff served State Farm with a request for admissions on September 11th of 2025. State Farm had until October 13th, 2025 to respond to those requests for admissions. In those requests for admissions, the plaintiff asked State Farm to admit that they issued policies for coverage in the amount of $30,000 per person, $60,000 per incident, that the policies referenced were valid and in effect at all times relevant, that the plaintiffs complied with the contracts of insurance, and that State Farm owes plaintiffs the coverage for the injuries they sustained in the underlying collision. By failing to respond timely, those admissions are admitted as a matter of law, the plaintiff contends. State Farm did not move for a protective order or to withdraw their admissions before plaintiffs submitted their motion for summary judgment. In this case, the plaintiff's not asking the court to rule on the merits of this action, simply to establish what State Farm has already admitted, that they owe the plaintiffs coverage in this case. If State Farm was now, after all this time, allowed to withdraw their admissions, the plaintiff would be prejudiced in way of having to relitigate an issue now conclusively established as a matter of law and expend additional time and resources into that investigation, requiring further discovery, etc.
All right. Mr. Gaither?
Good morning, Your Honor. May it please the court that I ask that this court deny plaintiff's motion for partial summary judgment. Since I am not the original attorney that handled this case, I will not go into all of the arguments outlined in the briefs and the pleadings that were submitted regarding this motion. I will just rest on those arguments there, but I would like to basically try to make this argument as simple as possible. First, let me give a mild background. This case involves a multi-car rear-end collision where a tractor-trailer hydroplaned and rear-ended the middle car. The middle car then struck plaintiff's car. At the time of the incident, plaintiffs were insured with State Farm and had a uninsured motorist coverage under a North Carolina policy. That's going to be important later, with insurance limits of $30,000 over $60,000. Okay. Now, according to the terms of the North Carolina policy, plaintiff only has uninsured motorist coverage. In Georgia makes those two products one: uninsured motorist coverage and underinsured motorist coverage. So when you purchase coverage in Georgia, that's one. In North Carolina, those are two separate products that have to be purchased individually. Now, with that being, and so what happened then? The defendant trucking company, it appears they tendered their limits in response to the plaintiff's global demand. So I believe the lawsuit was filed so plaintiff could pursue the coverage, and requests for admissions were filed. However, the Civil Practice Act permits a party to serve on another party a written request for admissions of matters that relate to statements or opinions of fact or of the application of law to the fact. But a matter is only conclusively established only if a response to a request for admission is unambiguous and is not subject to a different meaning. Now, the request for admissions that are in question here, plaintiff's request for admission number 8, admit you issue a policy or policies of underinsured / uninsured motorist coverage, covering at least one of the plaintiffs in this matter in the amount of $30,000 over $60,000. That was admitted. And that is actually a true statement. It's not an accurate statement. And it's very ambiguous. Again, if this was a Georgia policy, it would be pretty clear cut because Georgia sells one product, underinsured and uninsured. The problem here is that while that is a true statement that State Farm provided coverage under an uninsured motorist claim, it did not provide coverage under a underinsured motorist claim. And this position number 8 is very ambiguous because it can have a different meaning, which it does. Plaintiff knows full well they did not purchase a policy with underinsured motorist coverage. The long story short, Uninsured motorist coverage covers someone when the other party doesn't have insurance at all.
What it is.
Underinsured motorist coverage.
The reason I'm looking
I'm
at you
sorry?
is because, so the basic rule is if you fail to timely respond to requests for admissions, those are deemed admitted. What you're saying is that the admission is not, that the court shouldn't rely on those admissions or allow the parties to rely on those admissions because the North Carolina has a different view of uninsured versus underinsured. But the question itself asks for both. And because nobody responded in a timely manner, they're allowed to say that they're allowed to take as true that either uninsured or underinsured policy was issued. Now, how they use that at trial is different than whether it should be deemed admissible. I'm not sure why we would be doing requests for admission responses late because that's sort of like the bedrock of the Civil Practice Act is those things have to be timely addressed, or there has to be some communication between the parties that would give you additional time or relieve you from that burden. So at this point, I am not sure why that being deemed admitted is an issue that you think the court can't or the parties can't rely on. Like, okay, so so I get underinsured versus insured, but so they say you said okay, we have admitted an underinsured or an uninsured policy. That's where we are. That's the slash. So what's the issue?
Because the issue that is still very ambiguous. There is an argument that this is not just North Carolina's view, it is a contract issue. And the contract specifically states that they've only purchased uninsured coverage. I mean, uninsured
So what
coverage.
you're
They
saying
did not
is
purchase
if
underinsured
somebody
coverage.
actually answered this question, this would have been no to uninsured, but yes to underinsured, or is it the reverse?
And that's the way the best practice should have been answered that way. But even though it was admitted, and even if it's deemed admitted, it is still ambiguous because this still can have a different meaning, which it does. And plaintiff still has the burden, even with this admission. If we go to trial, I'm going to withdraw our answer and we're going to come in the case as the name of the named defendant. And then guess what? Plaintiff still has to prove that there's uninsured motorist coverage, and there's not in this case.
Well, I mean, they seem willing to do that. Mr. Hamby, you understand the argument that he's making. I understand it. Did you wish to
Yes.
respond?
And
Because I'm not sure that just okay, so the fact that you're saying that the court should not consider this, just strike that particular response to the request for admission, but all the other ones are still deemed admitted.
Well, let me go down. So number 9, the policies referenced in the proceeding. Please admit the policies referenced in the preceding requests were valid and in effect at all times. Admitted. That's no problem. But then we come to number 10. Please admit that plaintiff Lavinia Vance has complied with the contract of insurance with you. Response: denied. Plaintiff Emmanuel
That's the
Gary has
response
complied
you
with the
would have
contract of insurance.
if y'all made a response. That's what you would say, not that you made such a response.
And I'm coming in from the back end, Judge. So I can
got
only
that, and I'm not,
presume at this
Mr.
point.
Gaither,
Yeah,
I'm not questioning your professionalism or your ability to practice. What I'm
I
saying
understand.
is certain things are hallmarks of civil practice. And if somebody doesn't respond to requests for admissions timely, then those admissions are deemed admitted. And the party who wishes to use them gets to use them and present them that way. Now, not that an argument can't be made to the converse, but when you get before a jury, well, these things have already been admitted. How do you now, like, do I just excuse the fact that these weren't timely responded to? How do we back that up?
And that's why I said I'm gonna when I started the argument. That's why I said any arguments that were made as to how and why, I'm gonna just have to simply rely on the pleadings that were already filed. I'm just not in the best position to argue what happened, give an explanation for why it happened, because the only thing I would be doing is reading to the court from the pleading what the pleading already says. So I'm just being completely forthcoming
you.
in that. But what I am saying is that now looking down the road procedurally, even with the one admission in number 8 being deemed admitted, it is still unambiguous. And I do not believe that plaintiff can waive their burden of proving coverage when the carrier doesn't even have to file. We didn't even have to come into the suit. We could have just waited until let the defendant get a judgment and then deal with it. But then, of course, you run the peril of not being able to participate. So we did respond, but we are going to withdraw our answer. And so now that still places the plaintiff back in the same position he or she was in prior to the suit being filed. You still have to prove that there was coverage. And that's what I'm raising. That number 8 is still unambiguous. I mean, it is ambiguous because the way it is written, underinsured versus uninsured motorist coverage. In these cases with contract issues, you have to have some specificity. And plaintiff again knows that was a North Carolina contract, and that if this issue is raised on appeal, which it would be on some type of interlocutory appeal, now we're going to be asking the courts to look beyond what the mere request for admission say and look at the entire package. You have a Georgia policy that would include this language, but then this insurance product was purchased under North Carolina policy. How do you get around that, Mr. Plaintiff? It looks like you're trying to circumvent that by adding some ambiguous language in a request for admission that still could be there's an argument that could be made that that's ambiguous. And that's all I'm saying, that's an argument to be made that admission is ambiguous. And so the fact has not been conclusively proven.
And Your Honor, may I respond?
Okay.
From my perspective, reading a request for admission that asks them to admit that insurance coverage exists, I don't think that that's ambiguous. I don't think a lot of people would argue that's ambiguous. And I appreciate counsel's arguments today. I don't believe that those arguments were contained in their brief. And I would propose to the court that whether or not, State Farm ends up taking some procedural move in the future, I don't think that goes to the essence of what we're talking about today. If they lose this and then there's something they can do later to make up for it, okay, that's fine. But I don't think that would affect what the court is looking at today as far as whether or not these admissions were timely responded to and the effect of their failure to timely respond to those admissions. And I don't believe, like I was stating to the court, that these arguments were addressed in their briefs.
Before we leave this path, is there any case law that anyone knows of that says if even with deemed admissions, if a contract counteracts what the admissions say, then the court has to take some action with respect to the fact that the contract counteracts those admissions?
I do not, Your Honor.
I don't have a case at my hands right now, Judge. The only case I would have that would come close to looking at the case as a whole is government employees. It's a Geico case versus Morgan at 341 Georgia Appeals 396. And I'm raising that to 2017. I'm raising that case just for the proposition that a matter is conclusively established only if a response to a request for admission is unambiguous and not subject to a different meaning.
Your Honor,
Yes.
If I may, I think State Farm had an opportunity to make this argument. They could have denied this, and in doing so, explained the nuances of their policy. But I would argue that they have now lost that ability to retroactively do so, and that doing so does prejudice the plaintiff. And as an example of this argument, there's going to be significant litigation that we would have to go through now to get to the root of this problem or this coverage issue that has, as a matter of law, been admitted. And I think that may further strengthen the plaintiff's argument they would be prejudiced.
All right. Well, I will give it a few more minutes of consideration, and then I'm going to make my decision. But thank you all.
Thank you, Your Honor.
Thank you, Judge.
All right, y'all are excused. Unless you have something else on my calendar.
That's it. Thank you, Your Honor. Have a good day.
All right.
I was gonna say, I was just gonna ask just for clarity, are we excused? You will send us your decision, or do we need to hang on? Okay, thank you,
Yeah.
Judge. All right,
Thank you.
take care.
You too. All right, Demia Hudson versus Michael Reynolds and Greenwood Motor Lines.
Hey, good morning, Your Honor.
Morning, Judge.
This is Jason Stewart on behalf of the defendants, R&L Carriers and Mr. Reynolds. And today we are here on defendant's motion for partial summary judgment. Just to provide some context, this auto negligence case arises from a very minor rear-end collision, August 19th of 21. A plaintiff was attempting a right turn. Mr. Reynolds was driving a commercial tractor, tapped plaintiff's bumper from a rolling stop, and as Your Honor is well aware, there's a dash cam video which is attached to our brief as Exhibit E. There's no dispute that Mr. Reynolds was driving the commercial vehicle in furtherance of R&L's business. So let's get to the issues for today. The motion addresses the direct negligence claims against R&L, which are negligent hiring, retention, supervision, negligent entrustment, negligent training, negligent maintenance, inspection and repair, and negligence per se. As a matter of efficiency, it's my understanding at the moment, just in receiving an email from Mr. Pate, that plaintiff will not be opposing today in the hearing our motion for partial summary judgment as to the claims for negligent hiring and retention, negligent entrustment, negligent per se, and negligent inspection, maintenance, and repair. And that's my understanding, and I'll send it over to Mr. Pate for a brief moment just to confirm those things on the record.
Yeah, that's correct, Judge Hayward. I sent an email to Jason a few moments ago, letting him know that plaintiff's not going to oppose summary judgment on the negligent hiring, negligent retention, negligent entrustment, negligent per se, negligent inspection, or negligent maintenance claims against R&L carriers.
So that leaves
We only
supervision and
oppose summary.
training.
We only oppose summary judgment on the negligent training and supervision claims.
Okay. All right, Mr. Stewart, are you prepared to pivot and just argue those?
Yes, Your Honor.
All right.
And I'll rest on the brief and plaintiff's acknowledgement there of not opposing those points. And I'll just address the negligent training and negligent supervision claims.
Okay.
There's no evidence that R&L knew or should have known of Mr. Reynolds' propensity to engage in behavior which is substantially related to any other conduct on the incident date. And in order to survive a motion for summary judgment on the negligent supervision claim, there has to be a specific showing. And what plaintiff has to show is that there were some sort of similar incidents, produce some sort of evidence of incidents similar to the behavior that caused the injury at issue. And that is the rule of law cited in Remediation Resources Inc. case 281 Georgia Appellant 31. It's a 2006 case. Here's what the undisputed facts show. Mr. Reynolds had a clean driving record 7 years before the accident. Mr. Reynolds had no citations in the 7 years before the accident. And Mr. Reynolds was not involved in a motor vehicle accident in which he was the at-fault driver during those 7 years. Plaintiff has offered no rebuttal evidence to dispute those facts I just stated, and he can't do so. And because that's not an option, what plaintiff is forced to do is to rely on misleading evidence about 2 motor vehicle accidents that occurred before the date of accident in which at-fault drivers hit Mr. Reynolds. And I'll address those in a little bit more detail. They also cite a citation from 2001, as well as a citation from 1997, both before Mr. Reynolds' employment with R&L and 20 years before the date of the accident. Mr. Reynolds currently is in his 60s. He was 58 at the time of the accident, and plaintiff is porting and directing this court to citations that occurred when Mr. Reynolds was in his 30s. And because there's no rebuttal evidence that they can offer as to the negligent supervision claim, that claim must be dismissed. I want to also succinctly state our position as to the negligent training claim. They must show inadequate training caused a reasonable foreseeable injury. And they can't show that here. Now, I want to take a little bit of an aside. At the time of the accident, Mr. Reynolds had been driving for 2 decades. Training was not a requirement, but they're claiming that there was an issue with the training. Here's what the undisputed evidence shows. It shows that R&L held monthly safety meetings at its terminal for drivers since at least 2002. And these safety meetings address safe driving, driving in different weather conditions, regulatory changes, as well as other issues concerning safe vehicle operational. And in addition to that, R&L also offered driver trainers as refreshers to answer any driver's questions at the terminals. Now, how do we know that? It's because the person who developed the content for these meetings and the overall program, the Vice President of Safety, Joe Crissa, he testified in his deposition as noted within our briefs, and he explained this system. So what plaintiff has done and what they're seeming to argue is that this was not actual training, these safety meetings. Now, we can split hairs on an actual definition of what training actually is, but here's the real issue. Plaintiff can't show that inadequate training led to the accident. And that's it succinctly put. Now, going specifically to other facts I want to direct the court's attention to in terms of the negligent supervision claim. What the facts show is that Reynolds was an experienced, competent commercial driver who had a clean driver record for 7 years before the accident. How do we know that? We know that because R&L employed a reasonable DOT compliant program and measures to ensure that he was a competent driver from the time that he was hired in 2002, and he maintained that status up until the present day. In 2002, when he was hired, R&L checked his driving history through the application and pre-employment MVR. And in that application, Mr. Reynolds self-reported that, hey, I had a speeding violation way back in 2001, as well as an unspecified motor vehicle accident in 1997. Now, his pre-employment MVR run back in June of 2002, which is attached as Exhibit I to the brief, is clean. No motor vehicle accidents, no citations. And the MVR also confirmed that Mr. Reynolds had a valid CDL since 1997. He passed a road test, and based on all these measures taken pre-employment, he was hired. And he was driving for almost 25 years before the date of the loss.
Is there an industry requirement, Mr. Stewart, for drivers if drivers have been driving for a certain period of time, is there some kind of retraining or certification that they have to pass other than getting their CDL renewed? Is there some kind of retraining that they have to have periodically, like attorneys have to do CDLs, CLEs. Is there something that they're required to do in order to maintain their CDL periodically?
I'm not aware of anything that needs to be done in terms of additional training. Now, in terms of the CDL itself, they have to go to the DMV just like everyone else and get a new license whenever needed. And they have to, there's some requirements in terms of, maintaining a valid med card and stuff like that, which is done periodically. But in terms of the training for actually operating the commercial vehicle, I'm not aware of any requirements that any additional training needs to be completed by a driver. Once they're a CDL driver, have their endorsements, they're capable of driving. Now, during his employment, RNL, annually perform reviews and obtain MVRs each year. And the brief attaches the reviews and MVRs for the 7-year period that I just stated, and all of them show that he had a clear record. Now, during his deposition testimony, Mr. Reynolds stated that in 2019, another vehicle merged into his tractor trailer on I-285. He was not at fault. He was not cited. He also testified that in or about 2023, a hit-and-run driver rear-ended him in Clayton County. These were accidents that he was involved in, but he was not the at-fault driver. And there's no evidence that those accidents were a result of anything that he did. So plaintiff can't show that there's incidents similar to the behavior here that caused the incident in issue. And so because of that, their negligent supervision claim, it fails. Now, going to the negligent training claim, which is pending. It's undisputed that RNL offered the monthly meetings, which Gerald Crissa testified to. Crissa could testify with clarity because he designed the topics. He made the program, and he knew that they were addressing safe driving. Now, plaintiff's argument, if I kind of boil it down to the essence, is that the training was inadequate because no written tests were provided at the end. That's a red herring and a non-issue really here, because like I've stated, there's no requirement that there's training. Now, if plaintiff would be able to show that some training was given inadequately, or there was an issue with the training which resulted in the accident, that would be a different story. But here, that's just not the case. I do want to just point this I guess the elephant in the room here. The video pretty much shows exactly what happens. And the video shows that Reynolds was attempting to make a right-hand turn. Plaintiff was in front of him, and he testified, I thought that plaintiff had made the right-hand turn. I pulled up in a slow rate of speed, and I tapped her bumper. There's no evidence that inadequate training led to what happened that day. He made a mistake in terms of an error. And there's no evidence that the safety meetings or anything that Gerald Crissa testified to led to what happened that day. I think that the evidence kind of speaks for itself on that. And Your Honor, based on these arguments, we request that defendants' motion for partial summary judgment on the direct negligence claims be granted.
Okay. All right. So, Mr. Pate, with respect to the training, I asked Mr. Stewart, do you know of any additional training that has to happen periodically for Mr. Reynolds to have been a driver in good standing?
Yeah, what the regulations do require, Your Honor, and that's 49 CFR section 390.3 subpart E2, is that every driver shall be instructed regarding and shall comply with all applicable regulations. So this is an affirmative duty on the carrier to instruct, and it's not satisfied by a 15-minute meeting where the terminal manager reads from a paper. And so but RNL did not need a industry mandate. It set its own standard And that's from the deposition testimony of the corporate representative from R&L. She testified that R&L subscribed to ProTread, and in his words, it's a platform really designed for the driving of commercial motor vehicles with modules on driver skill sharpening. And he testified that R&L has driver trainers at every service center who are mandated with facilitating refresher training. And he testified that R&L's policies far exceed any specific regulation. But in this case, Your Honor, there's no evidence that Mr. Reynolds ever received a single ProTread module or ever sat with the driver training in the 21 years with the company. And the corporate representative further testified that R&L University tracks completion where a regulation requires recurrent training. And so R&L knows how to track training and does when a regulation makes it track. So for driving where there's no regulation, R&L still did not track any of the training or hasn't presented any evidence that that Mr. Reynolds got the training that he needed for the circumstances of this collision. So as it relates to the negligent training claim, Judge, so to establish a negligent training, plaintiff must show that the inadequate training caused a reasonable foreseeable injury, and that's the citation from Advanced Disposal Services Atlanta versus Marzak. That's 359 GA App 316. And in the briefing, defendants say plaintiff has no evidence connecting training to this collision, but Mr. Reynolds supplied it himself in answer to questions during his deposition from plaintiff's counsel. Reynolds' entire space management training was counting 4 or 5 seconds, and he said that's pretty much it. After 30 years with the CDL and 21 with this carrier, he has never heard of the Smith System 5 keys, which is an industry standard. And then when he was asked how he executes this exact maneuver, he listed right mirror, left mirror, both mirrors, and he never said the front that he looks at the front of his truck. Counsel in this deposition had to prompt him, and he said, "Yeah, I should have said it, but yes, I also need to look at the front of my truck when I'm making this maneuver." The 30B6 corporate representative for R&L, she stated that R&L does not teach its drivers to drive. Its vice president of safety said so. And so I think that's obviously, I think further proof that establishes plaintiff's negligent training claim against.
No, I kind of get it, because if I answer an ad for a job that says I have to have a driver's license and a clean driving record, and I have a driver's license and a clean driving record, they're not going to put somebody in the car with me and tell me how to brake and how to turn and how to steer and how to parallel park. They're going to assume I know those things because I've answered the ad and shown proof of having a clean driving record and the requisite license. So if she said, "Hey, we don't teach you how to drive," I get that. I'm not sure how that is better for your side. It's just common sense.
Well, I think a jury could find that a carrier who puts a man in a tractor trailer for 21 years and never teaches him to manage the space in front of him should foresee that he will one day fail to see the stopped car ahead of him. And I think that's enough to establish our burden of proof for a negligent training claim.
Okay. But is that all you have?
Well, I mean, it's coupled with the fact that R&L doesn't teach its drivers to drive. The entire space management training was counting 4 or 5 seconds. That's pretty much it. And he doesn't have, any training on the Smith system. So I think, and on top of that, R&L gave him no additional training after this collision happened. And I think that goes to both the training and supervision. Um, uh,
I get that, but
it's
we're
just-
not supposed to, I don't know that I'm supposed to consider remedial measures. If they were to train him after the collision, I don't know that that helps us as we are now, one way or the other. I do, I do want to look to whatever the industry standard is or whatever the standard is this company set for themselves with respect to how their drivers are managed or how much additional um, professional training that they have or professional, meetings that they have to attend or things like that. But I don't know that somebody comes into a profession that they've been in for 30 years. They work for the same company for 21 years, and then they have an accident. And 21 years in, we say that they haven't been properly trained by the company that they're working for. Maybe if it was a year in, it'd be a little bit easier to see, but 21 years in, and no accidents. And now he has an accident on the 22nd year. But the argument is made that he wasn't properly trained. So it was just luck all the previous 21 years.
Well, I don't know if it was luck or what it was, but I think his lack of being able to articulate how he was trained on these type of events is supports our claim for negligent training and supervision against R&L.
All right. All right. Well, let me consider it carefully and I will get an order to you. And you all have made my job a lot easier by agreeing to some things. So that leaves just the requirement of looking at the supervision and training piece.
Okay.
Thank you.
All right. Thank you, Judge.
Anything else?
No, Your Honor.
All right. Thank you so much.
All right. Have a good day.
All right.
You
Thank
too.
you.
All right. All right. So we're in the 11 o'clock hour. I'm going to call the 11 a.m. calendar. All right, the first case on the calendar, Falcon Property Management, Mary Mills, David Mills versus Wanda Craig. That case has been transferred. There was a change of venue. So anyone here on that case, you're free to go at this time. The next case is Prestige Financial Services versus Robert James Williams. Anyone here on Prestige?
Joshua Thompson for plaintiff, Your Honor.
Robert James Williams. Last call for Robert James Williams. All right, so this is case 2025 CV 00595, Prestige Financial Services versus Robert James Williams. Mr. Williams has not appeared for the call of the calendar. I have that he was served in this case on March 30th, 2025. I'm sorry, March 20th of 2025, and filed an answer on April 25th of 2025. Plaintiffs filed a motion for judgment on the pleadings, and the hearing was initially rescheduled, but we're here today for a determination of the motion. All right, and go ahead, sir. Mr. Thompson.
Yes, Your Honor. So this was a suit on a retail installment contract for the purchase of a vehicle described in the complaint. One moment. The contract was assigned to Prestige, and the undisputed evidence shows that the defendant signed the contract. There's a balance owed on the contract, and the defendant has not paid the debt owed after proper demand. We have some case law with Holland Insurance Group, LLC versus Senior Life Insurance Company, 329 Georgia Appellate 834. A
All right.
motion for judgment.
I'm sorry. So you said this is an assignment. So he purchased the car from a company, and then they assigned the financing to you all,
That is correct,
your
Your Honor.
client. Okay.
It's listed on the note,
All
the
right.
assignment.
All right. Go ahead.
Holland Insurance Group, LLC versus Senior Life Insurance Company, 329 Georgia Appellate 834. A motion for judgment on the pleadings is proper when the undisputed facts that appear from the pleadings establish that the movement is entitled to judgment as a matter of law. When Mr. Williams filed his answer, the only averment that we could take a look at is stating that he returned the vehicle. There was no other substantive answer or denial of any claim on the complaint. So the plaintiff shows the amount on the contract, and the defendant has failed to submit any evidence rebutting the amount owed on the contract. So the plaintiff is therefore entitled to judgment on the pleadings as a matter of law and fact on its claims in the complaint against defendant. So the undisputed material facts here is that on October 23rd, 2020, defendant executed the retail installment contract. The note was assigned to Prestige. The defendant defaulted on the contract by failing to pay amounts owed. On January 1st, we filed complaint in 2025. Defendant was served on March 20th, 2025. April 25th, 2025, defendant filed an answer to the complaint. In his answer, he stated that I voluntarily surrendered the car. After application of the payments, defendant is indebted to plaintiff on the note and the principal amount of $10,896.72, accrued interest in the amount of $5,604.17 as of January 26, 2026, plus interest accruing thereafter on the principal amount at the rate of 19.99% per annum until paid in full under the terms of the note. Fees and other charges in the amount of $839, attorney's fees and expenses of litigation on the note, and OCGA 13111A1 in the amount of $2,475.13 through January 26, plus additional attorney's fees accruing thereafter and court fees and costs of litigation.
All right.
Now, we do have a brief in support of judgment on the pleadings, and I can go through that.
You have your affidavit with that?
I believe so, Your Honor.
Okay. All right. So $10,896.72. That's the balance owed.
That's the principal, Your Honor.
Okay. And has the car been resold?
I believe it has been resold as listed on the complaint.
All right. $5,604.17. Interest?
The interest is
that what I got for interest?
Yes, Your Honor. One moment. Let me just take a look here.
I'm just trying to go through the numbers and make sure I have before I pronounce judgment.
Yes, $5,604.17 is the accrued interest.
Yeah, and that's at the rate of 19.99% per annum. $839 in cost and $2,475.13 for attorney's fees to date.
Yes, Your Honor.
All right. So the court is going to grant judgment in those amounts. Plaintiff has presented its case for liquidated damages for failure to complete a retail installment contract for a vehicle. Even though the vehicle was returned, that does not alleviate the defendant from having to satisfy the terms and conditions of the contract unless they have made another agreement with the finance company. The court is going to grant these amounts as prayed for today. And if you will present a proposed order to Ms. Kiara Powell. Ms. Powell, if you'll put your email address in the chat, then you can present that and we'll go ahead and sign.
Thank you very much, Your Honor. I certainly appreciate it. That's my only matter before the court today. May I please be excused?
You may, sir.
Thank you very much.
All right. All right. The next case is Capital One North America versus Thais L. Currington. Thais Currington, or anyone here on behalf of Capital One?
I'm here, Your Honor.
All right. Anyone here on behalf of Capital One?
Your Honor, if I may ask, who's the attorney of record on that?
Richard Howe.
Okay, thank you.
Wait, no, I'm sorry. I'm looking at the wrong one. Capital One. Christopher Tang.
No, that's not mine. Thank you, Your Honor.
Okay. All right. So, so this is Miss Powell?
Yes, ma'am.
So I have that there's a jury calendar. This is set for a jury calendar on August 24th of 2026.
Yes, ma'am. These cases were scheduled for the civil motions calendar and the jury calendar, but parties were informed to appear today.
Okay. All right. So
I will say that plaintiff's counsel did appear on June 10th, but he was duly informed to appear today as well.
okay. I see it. All right. So the plaintiff is seeking, I guess, was seeking a judgment on this case. The plaintiff has not appeared and has had notice. So the plaintiff's case will be dismissed for warrant of prosecution. So Ms. Currington, can you turn your camera on, ma'am?
Yes, ma'am. Give me one moment. Oh, God. Yes, ma'am.
Oh, good morning.
Good morning.
So the Capital One North America, no one has appeared on their behalf. Because of that, they were seeking judgment for the amounts owed. The case is going to be dismissed for warrant of prosecution because they did not appear. So you're free to go at this time. It does not mean they will not still try and pursue the debt. So if you want to figure that out or work that out some way, you can do that. But just because it's dismissed today, I don't believe this is not a dismissal on the merits. It's a procedural dismissal. So you may want to speak with them or handle that in some other way.
Okay. Now, who did you say the attorney is?
I have as the attorney on this case, Christopher Tang, T-A-N-G. Now, the attorney who comes to court to argue these
I'm sorry,
is not
Your Honor.
always the same attorney who's been dealing with you or dealing with the back and forth between you and the company.
Your Honor, I apologize. I thought you said Christopher Kane, not Christopher Tang, T-A-N-G.
Tang.
I'm going to represent that case, Your Honor.
Oh, I'm sorry. He is here. So Mr. Henry has this case on behalf of Mr. Tang. All right. So Mr. Henry, do you have the particulars?
Your Honor, is it possible to meet Miss Coddington is her name?
Currington.
In a breakout room to discuss the matter?
Ms. Currington, if you want to talk to the attorney about a possible resolution of the case, where you all might be able to agree to something, you can do that. And if you come back and you have not made an agreement, then the court can hear both sides.
Okay, that'll be fine.
All right, I'll put you in a breakout room.
Thank you.
You're
Your Honor, I
welcome.
have another case on the calendar before going to the breakout room.
Okay,
So I'm just going to stick around until you call the full calendar. Is that okay?
yeah, that's fine. So Ms. Currington, I'll put you in a breakout room in a few minutes. Let me just finish calling the calendar, okay?
Okay.
All right, thank you, ma'am.
Mhm.
All right,
Judge,
the
you
next.
need to note for this case and any other cases that also received notice about the August 24th trial calendar that they will not be required to appear. The matter is going to be handled today. That's why they're here today. Do
Okay,
not appear, please, on the 24th.
I got you. All right, so the next case on the calendar is Calvary SPV1 LLC versus Josephine Aniora and Anchor Trust Health Systems.
Your Honor, if I may ask, who's the attorney of record on that?
That is Mr. Tang, also T-A-N-G.
I'm going to take that one as well.
Okay. And then next is Republic Finance LLC versus Rashonda Jones versus U.S. Aviation Group. Gregson T. Han or Han.
I'm here.
All right, Ms. Jones. Anybody here on behalf of Republic Finance?
You said the attorney's name is Gregson T. Han?
Yes.
That is me also, Your Honor.
All right. And LVNV Funding LLC versus Gloria Britton.
That's me, Your Honor, as well.
I'm here, Your Honor.
All right. Okay. So, all right. So did you want to speak with each of those people in a breakout room?
Yes, Your Honor, please.
All right. So ladies and gentlemen, I think it's ladies. Mr. Henry is handling each of these cases for the financial cases. And if you wish to talk to him about the possibility of resolving your case through an agreement, then you can do that. If you all don't come to an agreement, we can still hear your case. But if you wish to talk to them, let me say that what the benefits are. The benefits are that you all can make an agreement that is sensitive to what your income is currently. And it also addresses any questions that you might have of the plaintiff regarding anything with respect to the debt that is owed. So you all can have that conversation. The other issue is, I'm sorry, there's another page on the calendar. Public finance. The other thing is also is if you all agree to how the money is paid back, then I don't just issue a judgment. If I issue a judgment, then they can pursue it by garnishing your wages, garnishing your bank accounts, or through other means. But if you make an agreement, you may be able to manage how the money is paid back, and it might work out better for you. I'm not encouraging it in any way. I'm just explaining to you what the opportunities are. All right, the next case on the calendar is Progressive Premier Insurance. Ronald Lockley is the attorney, but he said he has a conflict, so we're going to hold for his report.
I'm here, Your Honor.
All right, and
Your
Giovanni,
Honor, can you hear me?
yes. I
Oh,
hear
sorry.
you.
I am here. I made it in time, so I'm here with my witness.
Okay, no problem. Giovanni Russell. Okay. Next is Midland Credit Management versus Narina Thomas Allen.
Who's the attorney of record, Your Honor, please?
Matthew Donahue or Nichelle Barnes.
That is me, Your Honor.
I'm here, Your Honor.
All right. I'm sorry, Thomas Allen.
Yes.
Okay, hold on a second. All right, and next is Christy, I'm sorry, Capital One versus Christy Chastain.
Good morning, Your Honor. Rohan Rapani here for the plaintiff.
Okay, all right. So I think that's, yes. So Mr. Henry, you got a bunch of cases. I can go ahead and put you in breakout rooms while I handle the case for Mr. Lockley and Mr. Rapani.
I would appreciate that, Your Honor.
All right. So Ms. Currington, Ms. Thomas Allen, Ms. Britton, are you all willing to speak with Mr. Henry individually about your cases?
Yes, Your Honor.
Okay,
Yes.
so I'm going to put you in the breakout room as soon as he comes out of the breakout room with one person, then I'll put the next person in. I'm going to start with Ms. Currington. And then we'll go from there, okay?
Thank you.
All right, so you'll see the breakout room appear on your screen. Once, I haven't done it yet, but once you see it, you can just go to your screen and click on that. And that'll take you into the breakout room. In order to get out of the breakout room, you should activate your screen, whether you do it through a cursor or by touch, and you should see leave breakout room. That will help you come back out, okay?
Okay.
All right, thank you. I'm gonna open the breakout room for Ms. Currington. Mr. Henry.
Thank you.
All right, so I think the remaining case that we cases that we called are first Progressive Premier Insurance versus Giovanni Russell, and then the next would be the case for Christy Capital One and Christy Chastain. All
And
right.
Your Honor, on the Capital One Christy Chastain case, I have not had a chance to speak to the defendant. If she is interested in speaking about it, I'd be happy to do so. I don't know if the court has multiple breakout rooms available.
I do. Ms. Chastain, are you willing to speak with Mr. Rapani about your case? Can you hear me, ma'am? Okay, so I'm having trouble hearing you. So maybe you're not speaking into the microphone. Okay, something's going on with your audio. You may want to come out of the Zoom and then come back in. But when you do, you're going to make sure that you choose device audio. 1 second. Look up real quick. I'm gonna there. All right. I think I was about to lose battery. All right. So, ma'am, if you choose, if you go to look on your screen, if you see something that looks like an old-fashioned microphone, and if you click next to that, there should be a divot going up. If you click on that, it may allow you to select your microphone, and you're going to look for your system microphone. If not, probably sometimes it's best to go out and come back in. If you ordinarily use a headphone at your job, you might want to put that back in too. That might be the issue. All right, so Mr. Lockley, while you're working on that, Ms. Chastain, so we can hear you. Yeah, and if there's a younger person, and I'm old myself, so trust me, I say this with all sincerity. If there's somebody in their 20s or younger, get them. They can help you figure it out. That's what I do. All right, so she did. So Mr. Lockley, you said you are here with your witness.
Yes, Your Honor. Miss Aisha Palmer, are you there?
She's on. Miss Palmer, can you turn your screen on for me? There you are. All right. So, Mr. Lockley, this is case 2026 CV 01887, Progressive Premier Insurance versus Giovanni Russell. Giovanni Russell has not appeared. And was served with the complaint and there's been no response. So there's default and the damages are unliquidated. All right, so Ms. Palmer, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. Mr. Lockley, your witness.
Thank you, Your Honor. Ms. Palmer, with whom are you employed?
Progressive Insurance Company.
And in what capacity?
I am a managed repair rep.
And how long have you been employed in that capacity?
20 years.
And by virtue of your training experience, are you familiar with the fair market value of vehicles before and after collisions?
Yes.
And the reasonable cost of repairing damaged vehicles?
Yes.
In your opinion, what was the fair market value, including tax and title, of the 2017 Nissan Rogue?
$19,273.03.
And did the amount of repairs exceed the difference of the value of the vehicle before and after the loss?
Yes.
What was the net salvage recovery?
$1,597.
So what is the difference in value of the vehicle before and after the loss?
$17,676.03.
And what was the loss of use incurred while the vehicle was being salvaged?
That was $1,152.43.
So what is the total amount of damages the plaintiff is seeking?
$18,828.46.
Your Honor, that's the principal amount we seek in addition to court costs and post-judgment interest. I did e-file a proposed order, but I can email one if it's not received.
I think if you e-filed it, that's fine. Ms. Palmer, is that all that you have today?
Yes, ma'am.
All right. All right. So on behalf of the Progressive Premier Insurance Company, court is going to grant the judgment, default judgment was granted because there was a failure to answer after the defendant was served, and this is unliquidated damages. Damages have been proven at this time. So on case 2026 CV 01887, the court is going to grant the total of $18,828.46. That would be the net value of $17,676 and 3 cents, plus loss of use of $1,152.43. All right.
Thank
Anything else?
No, Your Honor. That's all we have, if we may be excused.
Yes, sir. Thank you. Thank you, Ms. Palmer.
All right, have a great day, Your Honor. Thank you.
All right, you too. I don't see Ms. Chastain. Oh, there she is. Ms. Chastain, can you hear me? Ms. Chastain? There you are. Can you hear me? All right, so can you hear me, ma'am? All right, now speak. Ms. Chastain, try speaking now. Okay, you just muted yourself again. All right. Okay, now speak. Yeah, still not. Can you, I don't know, is the headphone wireless? Okay, I can't hear you, but if the headphone is wireless, can you give me a thumbs up? All right, so it might be something in the fact that the headphone is wireless, because we're not picking you up at all. You're gonna come on your phone, that's fine. There you are. All right, so Ms. Chastain, can you hear me?
Okay.
There you are. All right.
Can you hear me?
Yes, ma'am.
Ah, thank goodness. There you go. Man. Okay.
All right. So would you like to speak with Mr. Rapani about your case, or did you wish to go straight to a hearing?
Well, I've been in a Fresh Start program since November, so I guess I can speak to.
Okay, so you can explain that to him and ask any questions that you
Yes, that's fine.
All right, so Mr. Rapani, Ms. Chastain, I'm going to put you in breakout room number 3. You should see it pop up on your screen. Okay.
Okay.
Got it. Thank you, Judge.
No problem. Once you see it pop up, you can just touch on that, Miss Chastain. You should be able to go into the breakout room. Did you
Okay.
see it?
I saw it on my computer, but I don't see it on my phone. Wait. Oh, oh.
Oh, I might have put the wrong one in there. Hold on, let me see. Let's see on the phone. Breakout room number
Let's see. Join break.
Okay, there you go. All righty. All right, so ladies and gentlemen, if you will just be patient, as soon as Mr. Henry or Mr. Rapani come out of the breakout rooms, we'll proceed. Thank you. Just keep your devices muted.
Judge, I did have a question for you. I did file Chapter 7. I have my case number. I don't know if I still need to speak with him.
You're muted, Judge.
You probably do still need to speak with him. Can you turn your camera on for me?
Okay, so I still need to speak with him. Okay.
Yeah, because I'm not sure. I don't do bankruptcy. I do know that some bankruptcies can stay proceedings, but I have to, like, if you speak with him, then we can get an agreement about what needs to happen next.
Okay, thank you.
All right. Ms. Chastain, Mr. Rapani?
Yes.
Okay, Ms. Chastain, now I can hear you on both, so you're gonna have to turn one of the devices off.
Your Honor, I spoke with Ms. Chastain. We were able to come to settlement terms on this.
Okay.
And my plan is to draft a consent to forward her today to review. Would the court be willing to continue this for 30 or 60 days? I believe we should be able to just get that consent filed in the next week or so and have this taken off the court's docket.
Yes, that's fine. So, Ms. Powell, this case will be continued for 60 days, and then in that interim, you all, if y'all have reached a consent and you send it in, I'll go ahead and sign it, and the case will be resolved.
Great. Thank you very much, Your Honor. And I believe that is my only case before the court. May we be excused?
You may. Thank you.
Thank you.
Thank you,
Thank
Ms. Chastain. All right.
So, Judge, just for clarification, that they'll be brought back if
If
a consent hasn't reached in
if a
60 days?
consent isn't, yeah, if we don't receive it within 60 days, they'll be brought back.
Yes, ma'am.
Okay. All right. Thank you for that. All right. So Ms. Chastain, you're free to go. Ms. Jones and Ms. Thomas Allen and Ms. Britton, as soon as Mr. Henry comes out of the breakout room, then we'll put you in the breakout room. Thank you.
Thank you.
Ms. Powell,
Yes, sir.
I just want to make sure you got the email from me regarding Ms. Carrington's case.
Let me check right now. One moment. I have not received an email from you yet.
Try to send it to the right email.
But sometimes it does take a moment.
Okay.
How long ago did you send it?
Maybe about 3 to 4 minutes ago.
Okay. I don't have it yet. If you want to put your, I know I put my email in the chat, but just to be safe, if you'd like to chat me your email, I can also send you a test email.
Okay, no problem.
Okay, I just sent that over.
Okay.
I got your email, Mr. Henry.
Great. So I've reached an agreement with Ms. Carrington. Is it possible I can be moved into another breakout room? Or do I have to wait for Your Honor to return? Oh,
You're fine. Yeah, did Miss Brent Currington come out of the breakout room? Do you know?
Yes, I'm here.
Oh, okay. So Miss Currington, Mr. Henry's going to give you the paperwork that you all agreed upon. And once you all have consented to it, then I'll sign it and then it'll be filed and this will in my part of the case. Okay.
Your Honor,
Okay.
it has been sent over to Madam Clerk.
All right. So I just say this to everybody. If you make an agreement, all I say is that things happen. And if something happens where you feel like you may not be able to fulfill the terms of the agreement, either temporarily or for some longer term, please tell the your contacts with the plaintiff in advance so that they will know ahead of time and then they may continue to work with you or they may be able to do something else that helps you. But just don't stop paying. Okay. All right. All right. So, Miss Currington, you're free to go at this time. Miss
Oh, thank you.
Thomas, Miss Britton, you're going to go into the breakout room, and then Miss Thomas Allen will.
Thank you. Have a good day.
You too, ma'am.
Mhm.
So, oh, I'm sorry. I think Miss Jones is in there somewhere. Miss Jones, I'll get you. So, Miss Britton, I'm going to put you in breakout room number 2 with Mr. Henry.
Thank you, Your Honor.
All
Thank you,
right,
Your Honor.
Mr. Henry, I'm going to move you to breakout room number 2.
Yes, ma'am.
All right. All right. Thank you.
Your Honor.
Yes, Mr. Henry?
We reached an agreement with Ms. Britton. We forwarded it to Madam Clerk's attention.
All right. Ms. Britton, you're free to go at this time. Once I sign it, you'll get a copy of it.
Thank you, Your Honor.
All right, take care, ma'am.
You as well.
All right, Mr. Henry, I'll move you to breakout room number 1. I'll put Ms. Jones in breakout room number 1 and then Ms. Thomas Allen.
Thank you, Your Honor.
Um, all right.
Your Honor.
Yes, Mr. Henry?
So Ms. Jones has informed me that she filed some bankruptcy paperwork and she claims she filed it with, or she filed it with the court this morning. And she
Okay.
submitted to this court. I'm just gonna ask that we stay the matter for now and give my office a chance to review what she's filed.
All right. So in the case with Ms. Rashonda Jones, the court's actions will be stayed until I hear from the parties or from the bankruptcy court.
Yes, Your Honor.
All right. So Ms. Thomas, Allen, I'm going to put you in a breakout room with Mr. Henry. Ms. Jones, you're free to go at this time.
Thank you, Your Honor.
Thank you.
Judge, are we're staying the case?
Yes, we can't do anything because bankruptcy's been filed.
Yes, ma'am.
And Ms. Thomas Allen, I'm going to put you in breakout room number 2.
Thank you.
Hey, Judge, can you hear me?
Yes, ma'am.
Hey, when I came out of the breakout room, I couldn't hear what was being said, so I just logged out and logged back in.
Oh, I said that our court is our actions are stayed pending whatever the bankruptcy court does. So
Okay.
I'm not going to do anything on this case until I hear from you and Mr. Henry, or I hear from the bankruptcy court.
Okay, perfect. So do I need to stay?
No, ma'am, you're free to go.
Okay, thank you.
You're welcome.
Your Honor,
Yes, Mr. Henry?
I'm a little confused as to why we're here on this court case today. I'm looking at the court's calendar and it says judgment was already rendered in this case, Your Honor.
Ms. Powell?
Yes, ma'am. Give me 1 second to look at the notes. Okay. Yeah, defendant requested this hearing. Let me go back and check. Okay. So default was awarded in this case. The case is on this calendar because Ms. Thomas Allen requested a hearing. In her answer, she believed that she missed her court date. I'm pulling it up right now to get specifics.
Okay.
But she believed that she missed her court date, and generally the court, and there was no court date because she did not answer the initial complaint before plaintiff had the opportunity to file their motion for default judgment. Plaintiff filed their motion for default judgment. Ms. Thomas Allen had not answered, as I stated. And so default judgment was awarded. After it was awarded 2 weeks later, she wrote into the court requesting a hearing date. And I'm having an issue pulling up her exact motion, but what I have from my recollection is that she believed that she missed her court date and was failed to be noticed on it. And we just have a policy of when people answer on a judgment case, they have an opportunity to be heard in court. So if she's stating that she wasn't served with the initial complaint, then maybe there'd be an issue with service. But this was her opportunity to be heard that she requested.
Ms. Thomas Allen, so my records show that you were served properly. We didn't, because sometimes we have issues with Odyssey when we're given notices. So we didn't know if there was an issue with that you were going to raise with the hearing date or notice for the hearing, but we didn't get anything that said you didn't get notice.
Yes. So the second, well, I guess they served me the same. The first time I never received the first court date, I never received it. So when I finally got the second one, I guess it was kind of late and I went into the court.
Okay, so but
Just
this is the
judge, she did not, there was no hearing because she never
didn't file it.
answered the
Okay,
complaint.
so here's the thing, Miss Thomas Allen. I think what happens with a lot of people is they get confused because they think when they're served, the first time they're going to address the issue legally is when they have a hearing before a judge. But no, when you are served with the papers, if you read the summons that is on the front of the paperwork that you get, it tells you you have to respond in writing and you have a certain amount of time to respond in writing. If you fail to respond in writing, then the plaintiff is entitled to a default judgment. And in cases where they know exactly how much is owed because it's a contract, then those amounts can be granted. So I think the confusion was from sending in your information, we thought that you had not received notice of the hearing. But
We received the first one.
Notice of a hearing, right? But when you don't answer, there wasn't a first hearing. When you don't answer, it basically is that you've handed the other side of a victory in the case because you failed to present anything that the court can consider.
So what will happen in this case?
So that your judgment has been granted because you failed to answer. And so at this time now, talking to Mr. Henry is really about how you're going to pay or whether they're going to have to seek the payment of the judgment through other means that are legal in Georgia.
Okay, because can I make a payment arrangement? Because
That's what you would have to speak with Mr. Henry's client about if they're willing to do that.
Your Honor, at this time, my client is not willing to do that. My client is just going to go forward with the judgment, Your Honor.
Okay, his client is not willing to do a payment arrangement. And I try and tell people this when you're served with papers, even if you're talking to folk on the phone or if you're calling and you're trying to negotiate something, you still have to answer the legal papers. You have to read them. If you don't understand them, you have to get somebody to explain it to you because that's where a lot of people run into difficulty is you have to answer in court to even have standing to respond for the court to consider your position.
But that's the thing. I never got the first. That's why I never got it. And then when whatever paperwork I got the second time, that's when they said I had a court day, and I was like, but I just got the paper. And that's when I filed to.
So I have that you were served on August 12th of 2024.
I don't recall that. I know somebody was calling me
Miss
about that.
Miss Powell, do
The
you have
record
the
says that it was.
But do you know how much is my total that I have to pay? So you don't know how much, how will they proceed or?
Hold on a minute.
Because I have to
All
pay
right.
my rent and stuff. I don't know what's the.
Miss Powell, look up the return of service for me, please.
I have it up, Judge. She was personally served well, the effective date would be August 12th because it took more than 5 days for the affidavit of service to be filed, but she was personally served.
So somebody came to you and handed you papers, ma'am, in August.
August of 2024?
Yes, ma'am.
To the address of 2787 Shelley Lane, Ellenwood, Georgia 30294.
Correct. That's my address.
Yes, ma'am.
I don't recall. So what are my options? Because I have bills to pay.
Ma'am, I get it, but if you don't, there really are, you're really kind of out of options in this sense. If they're not willing to, if they've gotten a default because you didn't answer and they're not willing to work with you, they can pursue getting the judgment paid through whatever means are legal in the state of Georgia.
And do you know the total? And can the lawyer try to see if he could work something out?
What's the total,
So,
Ms. Powell?
so for
Mr. Henry?
the suit is, we sued you for $3,495.68 plus the court costs.
Okay, you said 3,000?
$495.68.
And court costs are usually $300 or less. So then I say this, Miss Thomas Allen, what happens is people start talking on the phone with whoever's calling them to negotiate the debt, but they also get served. And because they're focusing on talking to the people and negotiating, they don't focus on responding to the written documents and coming into court and giving an answer. And so a lot of times what will happen is people don't understand that they have to do both.
Yeah, I guess it was a miscommunication. Like I said, can he try to see if he could get me other options? Because I do have a family and then I got bills to pay.
I got you.
I don't.
Mr. Henry, is there some contact person that she can contact who may, I guess, be able to make this decision? He's saying that his client is not willing to negotiate at this point. They just will pursue the judgment. But
Your Honor, she can call 470
470
260 3700.
Okay, so 470.
240
Uh-huh.
3700.
Okay.
And you'll be able to speak to anyone there.
Okay.
Okay?
Thank you.
No
All
problem.
right, well, just remember and spread the word. If somebody comes to your door and hands you paperwork, or they give somebody at your house paperwork for you, and it says summons, complaint, any of those words, you have a time limit running as soon as it comes to your house.
Okay.
All right?
Thank you.
You're welcome. All right, so court will be in recess until the 1 p.m. calendar.
Thank you, Your Honor.
Thank you, sir.
Thank you, Yana. Have a good day.
You too.
Bye-bye.